Welcome back to this course on copyright and related rights law. Over the last 6 weeks, we have discussed 6 categories of subject matters: literary works, artistic works, dramatic works, musical works, sound recordings, and cinematograph films. Of these, we understood that the first 4 literary, dramatic, musical, and artistic works need to satisfy originality, wherein a minimal degree of creativity will be considered in order to see whether copyright subsists in such work or not. We have also seen that sound recordings and cinematograph films will have copyright subsisting in them despite not satisfying originality. In this week, we are looking to begin with the second component of our title, related rights. In related rights, we are going to look at performer rights, and in this particular session, we are going to understand what are the various definitions of performances in various statutes around the world. How this will help us is that it will give us a bird's eye view of how performances are seen in these jurisdictions, what are its components, and in what manner are any issues that seem to be arising with respect to their interpretations. No doubt, when I say performer, 1 or 2 types of performers must have immediately come to your mind: a singer and a musician are 2 performers who immediately we connect with when we think about a performer. This person in this image is both singing as well as playing the guitar, and in that sense, he is playing the music and singing the lyrics. What we see is that from this image, we can see a wholesome performance, but in terms of differentiating the performance, we can link it to a particular type of work. So, when we are considering this person playing the guitar, we are considering a performance of the musical work. When he's singing the lyrics, we are saying that it is a performance of the literary work as well as performance of the musical work because of the composition which is tied to the lyrics. What about this image? Again, something that is clearly in our minds, clearly etched in our minds of what a performance is. This is a dance performance. Similar to how in the previous segment we have discussed how performance can be linked to some kind of work, here as well, it is possible that we can link a performance such as this to a work. You would recall that if there is a work of choreography, then we can say that this performance is a performance of a work of choreography, which is otherwise a dramatic work. Let us now look at some definitions of performance. First, let us look at what performance means under the UK Copyright Act. Under this Act, you can see Section 180 states performance means a dramatic performance which includes dance and mime, a musical performance, a reading or recitation of a literary work, or a performance of a variety act or any similar presentation which is, or so far as it is, a live performance given by 1 or more individuals. What we can see from this definition is our understanding that a performance is in some way connected to a work is expressed by way of saying what kind of a work is connected to that performance. So, this is a dance or otherwise a dramatic performance. This is a person playing a guitar, or in other words, a musical performance. The difference you would recognize between a dramatic performance and a literary performance, as we had discussed, you would recall in the Institute of Inner Studies versus Charlotte Anderson decision that performances which are action oriented are dramatic works, and where there is no such action, they are literary works. There are some other important words which we find in this particular definition. For instance, you can see a use of the term variety act. A variety act or a variety show is something that we will understand. We will also understand a very important qualifier here, which is that a performance, in order to be considered a performance, is, according to this definition, a live performance. So, what do we mean by live in live performance? Let us first look at what a variety act or a variety show means. A variety act, by its very terminology, very literally, variety means distinguishability of performances. Therefore, in this definition, where it says a theatrical entertainment of successive separate performances, as of songs, dances, skits, and acrobatic feats, we see that a variety act is not just an act of a single kind of performance, there is a variety of performances. And we can see this in a kind of show in which several types of performances need to come together in order for that wholesome performance to be completed. Let us now look at what is the meaning of live in live performance. You can see it says of or involving a presentation, such as a play or concert in which both the performers and an audience are physically present. Of or relating to an event that is broadcast or reported as it is occurring. Involving or relating to communication as over the internet that occurs in real time, being in play. A common theme between these meanings is that the presentation is something which is happening as we speak. In recording this particular lecture, the delivery of the lecture that I am making, it is live. Or is it? These recordings will reach the audience after it has been recorded. But is it not live when it was being recorded? You can see these definitions point to the fact that in a concert where there is a physical presence of audience and the performer, that is something which can be considered as live. There is also the consideration of time here, which is in terms of perception. In terms of perception, this is something which is happening in real time. And therefore, with respect to something being live, can we say that perception of the audience of the performance is an inherent aspect of the performance? This is a question which we will answer once we look at the provision within the Indian Copyright Act as well. But before we come to that provision in the Indian Copyright Act, let us understand what presentation would mean. Present would mean to bring to someone's attention. Therefore, in considering the question of whether perception of the audience should be something which is instant. So, when the singer is singing, the audience is able to immediately appreciate this particular performance. Either it is physically in a concert or sitting across computer systems and watching it through live streams. Or is it possible that the recording of such presentation, which was effectively a live presentation, could be something that is perceived by the audience at a later point of time? And such a contemporaneous perception is perhaps something that is not required. Also, what do we mean by perception here? What kinds of perception will we have to consider? You can see, with respect to performance specifically, there is no such consideration in the UK Act as to what kind of perception are we referring to when we are referring to a performance as a presentation. Let us now look at the provision within the Indian Copyright Act. First, let us take a look at section 2Q. It says, performance in relation to performer's right means any visual or acoustic presentation made live by one or more performers. What do we see immediately? The Indian Copyright Act provides for two types of perceptibility. One type of perception is visual, and the other type of perception is acoustic, or by way of sound. Second, the Indian Copyright Act also prescribes the requirement of such a presentation to be live. But just like the UK Copyright Act, the Indian Copyright Act also doesn't talk about the requirement of an audience or not. Should there be contemporaneous perception or not? This is something which is not answered. In section 2QQ, illustratively, the Indian Copyright Act looks to explain who a performer is. And it says, performer includes an actor, singer, musician, dancer, acrobat, juggler, conjurer, snake charmer, a person delivering a lecture, or any other person who makes a performance. Provided that in a cinematograph film, a person whose performance is casual or incidental in nature and in the normal course of the practice of the industry is not acknowledged anywhere, including in the credits of the film, shall not be treated as a performer except for the purposes of Clause B of Section 38B. We will first consider an important case that arose before the Delhi High Court, which looks to answer whether recording of performances which are done without any audience being present at that point of time can be considered as performances. And once we are understood, then we will move to Section 2QQ and its provisos understanding as to what is meant by this exclusion of certain types of presentations from the ambit of performances. But in appreciating the case that has come before the Delhi High Court, we must understand that performances in the industry, such as the sound recording industry, the music that we hear on account of a sound recording being communicated, performances are recorded in studios. As you can see in this image, in a studio setting, audiences are not present. In fact, catering to the audience is done by way of communication of the sound recording in which the performance is incorporated. But reasonably speaking, if the only consideration is that a presentation has to be live in order for it to be considered as a performance, then when this lady is singing in a studio, is she not presenting live? Similar is the case with any kind of performer who you can see mentioned in section 2QQ. The same kind of situation which this lady finds herself in a studio is the situation in which I find myself in. In delivering this lecture, I am engaging in an act of recording, but because this recording is of a presentation which is live, does it require any presence of an audience? Because if an audience is required, then this presentation will not amount to a performance. And therefore, neither this lady nor I would have any performer right to exercise under the copyright framework. This interesting question came up before the Delhi High Court in this case of Neha Bhasin versus Anand Raj. What the court stated is while the definition of performer in section 2QQ includes within its sweep a singer, section 2Q defines performance in relation to performer's right to mean any visual or acoustic presentation made live by one or more performers. Every performance has to be live in the first instance, whether it is before an audience or in a studio. The logical consideration and the reasonable stance that must be considered in line with what this definition says in plain terms is that there is no requirement of an audience at the time of presentation. If indeed such a requirement were to be mandated, as I was explaining, this lady, on account of a recording that is done in the studio, would not be able to claim performer rights. The court then says, if this performance is recorded and thereafter exploited without the permission of the performer, then the performer's right is infringed. Following this, we can now say confidently that even if a performance is recorded in a studio setting where there is no audience present, performer rights will vest with the performer because that presentation was made live. And if the recording was done without the singer's permission, and if it is commercially exploited without the singer's permission, then that would amount to a violation of performer's right. We will now come to the second component in our understanding of the Indian Copyright Act definition of performance and performer. We have noted that A proviso to section 2QQ, which interprets performer, is saying that where a performance is casual or incidental in nature, and in the normal course of the practice of the industry is considered to be something that is not credited or acknowledged, then such a presentation would not be considered as a performance. What are they talking about? This particular proviso, firstly, was inserted in the 2012 amendment to the Indian Copyright Act. If this particular scene was taken from a film, the people present in this particular scene would be people who are referred to as junior artists or extras. This particular usage is demonstrative of the industry understanding that such a performer as an extra need not be directed in any particular sense. There is wholesale replaceability of such a performance, meaning that any one of us could be in this particular scene and still the scene will be fine. This is very different from considering senior artists who are playing specific character roles. There would be a dialogue, there would be certain kind of direction for that individual role. And such extras, performances are, as you can see, considered as casual or incidental in nature, and in the normal course of the practice of the industry, they are not acknowledged. Therefore, we understand that performances are those which are live, the perception of which is visual or acoustic in nature. They need not be performed before an audience, and there is a difference between a casual presentation as against a not casual presentation. The casual presentation is something which will not be considered as a performance, whereas the not casual performance will be considered as performance. The use of the term extra is in effect a usage which shows that apart from the performances that are necessary for a particular script, these performances are extra, and in a way also reflects that any person could play such a role, even devoid of any particular acting skill. A junior artist is another term, like I said, which is used, which shows some kind of a lack of skill. Let us now look at the Canadian Copyright Act and how it interprets performance. It says, performance means any acoustic or visual presentation of a work, performer's performance, sound recording or communication signal, including a representation made by means of any mechanical instrument, radio, receiving set or television receiving set. In a very interesting interpretation, you can see performance seems to be having a dual understanding, where one side explains that performance is something which is a performer's performance, which is something which has also been interpreted, and we'll take a look at it. And it also says that performance refers to sound recording or communication signal. This application of the term performance is in fact something which we will discuss in great detail when we are looking at economic rights, and then we will make a difference between the right to perform a work in public and the right to communicate a work to the public. But keep in mind that for now, we are focused on performance as a performer's performance under the Canadian Copyright Act. And this is how a performer's performance is interpreted. It says, performer's performance means any of the following when done by a performer. A performance of an artistic work, dramatic work, or musical work, whether or not the work was previously fixed in any material form, and whether or not the work's term of copyright protection under this Act has expired. B. A recitation or reading of a literary work, whether or not the work's term of copyright protection under this Act has expired, or an improvisation of a dramatic work, musical work, or literary work, whether or not the improvised work is based on a pre-existing work. A very interesting interpretation in which we see that there is a delinking that the Canadian Copyright Act does between a work and a performance. Something that we will look at in greater detail in the next session. But because we are taking a look at this particular provision, you can note that if a work is not fixed in any material form, then there can be a question of whether copyright can subsist in such a work. Despite any such consideration of whether a copyright is subsisting in the content or not, the performance will be considered as a performance. Therefore, copyrightability of the content, which could be based on a requirement of fixation, has nothing to do with the existence of a performance. Similarly, whether a work is having a term of protection or the term of protection has expired, that again does not lead to a conclusion that a performance does not exist. The performance has existed. The only question is, in a scenario where a copyright exists, whether the copyright holder has authorized such performance or not. Another important consideration here is the issue of improvisations. Where a performance improves upon a work, we are thinking about some kind of a modification. And this says, an improvisation of a dramatic work, musical work, or literary work, whether or not the improvised work is based on a pre-existing work. Such improvisations, even if based on a pre-existing work, would lead to a performance existing. The content itself, which is so generated, can be the subject of a different issue, which is more connected to the derivative nature of the copyrighted work and not so much a question of the existence of the performance itself. But very importantly, the Canadian Copyright Act throws in our discussion an understanding of performance that is dual in nature. One reflecting a performer's performance and another reflecting a type of usage of works and performance. Let us now look at another copyright act. This is the Australian Copyright Act. Under this Act, performance means a performance including an improvisation of a dramatic work or part of such a work, including such a performance given with the use of puppets, or a performance including an improvisation of a musical work or part of such a work, or the reading, recitation, or delivery of a literary work or part of such a work, or the recitation or delivery of an improvised literary work, or performance of a dance, or a performance of a circus act or a variety act, or any similar presentation or show, or a performance of an expression of folklore, being a live performance that is given in Australia, whether in the presence of an audience or otherwise, or that is given by one or more qualified persons, even if it is also given by one or more persons who are not qualified persons, whether in the presence of an audience or otherwise. Let us consider two very important inclusions in this particular provision. The first important inclusion is of the phrase expression of folklore. We have understood that a westernized understanding of intellectual property seems to be focused on creative expressions being generated by individuals. Therefore, the critical race theory suggests that community-based expressions must be given their due importance. And what we see here is that a reference to an expression of folklore is a reference to a cultural relevance of presentations which have their background in content which is otherwise in public domain. The inclusion of an expression of folklore is also reflective of the great amount of stress that is placed on such cultural protection that we find in Australia. The second phrase, which is of crucial importance, is a specific mention in the statute itself that a performance would be live even if it is not in the presence of any audience. In saying so, the Australian Copyright Act has removed any requirement for any clarification which would otherwise be a requirement in provisions where there is no such mention of an audience or not. Let us then also look at the French IP code, which states, save for ancillary performers considered such by professional practice, performers shall be those persons who act, sing, deliver, declaim, play in, or otherwise perform literary artistic works, variety, circus, or puppet acts. What we had seen in the proviso that is added to Section 2QQ of the Indian Copyright Act, the French IP Code calls such presentations and such performers as ancillary performers. We can say that such performers are extras or junior artists or the kind of performers who can be replaced very easily by any individual and no particular skill is required. Let us also look at the Senegal Copyright Act, in which an interpretation of performers reads as follows. Performers means actors, singers, musicians, dancers, and other persons who act, sing, deliver, declaim, play in, or otherwise perform literary artistic works, including variety, circus, or puppet acts, or expressions of folklore. We have seen that definitions of performance and interpretations of performers vary to some extent in the various acts that we have considered. But one thing is clear, there is a clear connection between works and performances. In other words, where there is a work in existence, a performance of the work is something which would be related to the work. In other words, a performer right is a related right to the author's right in the work. We will discuss this in much more detail in the next session, where we are going to make a comparative distinction between a work and a performance. Thank you for joining me. See you all in the next session. Thank you.